Cardinal George Pell, on 12 December 2018, you were convicted by a jury of 5 charges of sexual offending by you against 2 young boys in 1996 and 1997 in St Patrick's Cathedral, East Melbourne. You were convicted of 1 offence of sexual penetration of a child under 16 years and 4 offences of committing an indecent act with or in the presence of a child under 16 years. The jury unanimously convicted you was comprised of 12 men and women randomly selected from the community. Initially there was a jury of 14 who heard the evidence and arguments of counsel and who received directions of law from me over the course of some 5 weeks. The jury was then reduced to 12 by ballot at the time of the deliberations. The jury deliberated for almost 5 days before returning their verdicts of guilty on all of the charges. Before I commence to examine the specific issues put to me on your plea, I am mindful that I am sentencing you within a unique context. It is important that I acknowledge that context so that I can make plain to you and to the community what my sentencing of you involves and what it does not involve. Let me first say something about this context. At the time you returned to Australia to face these charges, you were one of the most senior figures within the Catholic Church globally. You remain a cardinal of the Catholic Church. You are a figure of significant interest to those of the Catholic faith and to those throughout Australia more generally. There has been extraordinary and widespread publicity and public comment which has surrounded you for a number of years. Some of this publicity has involved strong, trenchant and sometimes emotional criticism of you. Indeed, it is fair to say that in some sections of the community you are a publicly vilified figure. Finally, I am also conscious that I am sentencing at a particular time where in recent years there has been the exposure of child sexual abuse within institutional settings, including within the Catholic Church. Having said a little about this context, it is important for me to now make some remarks concerning how this context relates to my sentencing of you today. First, I am required to sentence you today in accordance with the rule of law. This is a critical feature of our criminal justice system. The rule of law demands that when I sentence you, I must do so independently of any outside influences, only upon the evidence before me, and upon established legal principles. This means sentencing without fear or favour. Further, you are to be punished only for the particular wrongdoing you have been convicted of on this indictment of sexually abusing 2 boys in the 1990s, and only of that wrongdoing. It is critical that you understand that this is the basis upon which I sentence you today. It is also vital that the community understands this as well. As I directed the jury who convicted you in this trial, you are not to be made a scapegoat for any failings or perceived failings of the Catholic Church. Nor are you being sentenced for any failure to prevent or report child sexual abuse by other clergy within the Catholic Church. You have not been charged with or convicted of any such conduct or failings. This leads me to say something to other victims of clerical or institutional sexual abuse who may be present in court today or watching or listening elsewhere. This sentence is not and cannot be a vindication of your trauma. Cardinal Pell has not been convicted of any wrongs committed against you. Cardinal Pell does not fall to be punished for any such wrongs. I recognise that you seek justice, but it can only be justice if it is done in accordance with the rule of law. For me to punish Cardinal Pell for the wrongs committed against you would be contrary to the rule of law, and it would not be justice at all. Next, in sentencing you today, Cardinal Pell, I am not sitting in judgment of the Catholic religion or the Catholic Church. It is George Pell who falls to be sentenced. Finally, with respect to these preliminary observations. Over the last period, we have witnessed, outside of this court and within our community, examples of a witch hunt or lynch mob mentality in relation to you, Cardinal Pell. I utterly condemn such behaviour. That has nothing to do with justice or a civilised society. The courts stand as a bulwark against such irresponsible behaviour. Cardinal Pell, I want to acknowledge that in sentencing you today, I do so on the basis that you are a member of the community, like any other. Most importantly, while I must punish you for your offending, like anyone who falls to be sentenced by our courts, you are entitled to the balanced and steady hand of justice. I now turn to the facts of this case. You fall to be sentenced on a basis consistent with the jury verdict on your trial. It was common ground at the plea that this effectively means that you are to be sentenced on the basis of the account of the victim J, who gave evidence at trial. Your counsel accepts this. I must at law give full effect to the jury's verdict. It is not for me to second guess the verdict. What this means is that I am required to accept and act upon J's account. That's what the law requires of me, and that's what I will do. In the latter part of 1996 and into 1997, whilst Archbishop of Melbourne, you conducted Sunday solemn Mass at St Patrick's Cathedral in East Melbourne. The two victims, one of whom is now deceased, were choristers, or choir boys, who performed singing duties during Mass. They sang in furtherance of a singing scholarship each had with a private Catholic high school. I have anonymised my sentencing remarks so that the identities of the victims are not published. And in these anonymised remarks, I shall refer to the victims as J and R. The matter involves two episodes of offending. Turning to the first episode. In the latter part of 1996, at the conclusion of one Sunday solemn Mass, which was delivered by you, the victims formed part of a procession outside of the cathedral, walking back towards their choir room. The victims were still wearing their choristers' robes. During this time, without asking permission, the victims separated themselves from the procession. They made their way via the priest's sacristy corridor to the priest's sacristy. This area was off limits to the public. The priest's sacristy was also customarily off limits to choristers. Once inside the priest's sacristy, each of them drank some sacramental wine kept in an alcove within the priest's sacristy. After Mass, you entered the priest's sacristy alone. You were still robed. The priest's sacristy was the area you used for disrobing at the time. When you entered the priest's sacristy, you planted yourself in the doorway and said something like, "You're in trouble," to the victims. You and the victims sort of froze at that moment. Then you started to move something underneath your robes, like your trousers or belt. Shortly after this, you committed an indecent act upon R, who is now deceased. This involved pulling R aside, pulling out your penis, grabbing R by the back of his head with one hand and placing R's head and face in close proximity to your genital region. This occurred while R was crouched in front of you and you were standing. R was squirming, struggling and flailing while this was occurring. J saw R's face. R was terrified. At that point, R said to you, "Can't you let us go? We didn't do anything." R also called out no and help. This incident with R lasted about a minute or two. This is charge 1 on the indictment, indecent act. A short time after this, you turned your attention to J. You then sexually penetrated J. This involved pushing your erect penis into J's mouth. You pushed J's mouth onto your penis for a short period of time, in the order of about 2 minutes. J was, to use his words, freaking out when this happened. You were standing and J was pushed down, crouching or kneeling. This is charge 2 on the indictment, sexual penetration. You then committed further indecent acts with J. You told J to take off his pants and you started touching his genitalia with your hands. This is charge 3 on the indictment. While this was occurring, you began touching your own genital area with your other hand. These acts occurred over a minute or two. This is charge 4 on the indictment. Both charges 3 and 4 are indecent act charges. Once you stopped, Jay put clothes back on, and J and R left the room. They eventually rejoined the choir. Both J and R were present together in the pre-sacristy during the whole of the offending. At this time, both J and R were aged 13 years of age. During the incident, J and R were crying and sobbing. J and R called out, but it was at a level of whimpering and whispering. At some point, you told J and R to be quiet because they were crying. Now turning to the second episode of offending. Over a month later, following Sunday Solemn Mass at St Patrick's Cathedral, Jay was walking along the back corridor that leads past the pre-sacristy. You were also walking in that same area. You had either just presided over or delivered Sunday Solemn Mass. You were in official robes. Jay was in his chorister's robes. You pushed yourself up against Jay against a wall and then squeezed Jay's genitals for a brief period, for approximately 1 to 3 seconds. You then desisted and kept walking. This is charge 5 on the indictment, another indecent act charge. I now turn to the impact upon the victims in this matter. The prosecution tendered 2 victim impact statements, being a statement of J and a statement of the father of R. In describing the impact of your offending on J and R's father, I am mindful that neither wish to have their statements read out aloud in court, so I will be paraphrasing. In relation to the victim J, these crimes have had a significant and long-lasting impact on J's emotional well-being, which has in turn affected many aspects of his life. Jay has experienced a range of negative emotions which he has struggled to deal with for many years since this offending occurred. Sometimes these feelings have been overwhelming. In particular, the offending has had a significant impact on Jay's relationships. He has found it difficult because of issues of trust and anxiety. I take into account the profound impact that your offending has had on Jay's life. In his victim impact statement, R's father expressed that he felt shocked and upset to learn of what had occurred to his son. He felt that he'd failed his son. I take this impact into account. I do not take into account R's father's grief for the loss of his son. It is common ground between the parties that R's death is not related to the offending against R. The defence argue that R's father was not a victim of the offence for which I am sentencing, because the offending did not have a direct impact on R's father. At the plea hearing, I rejected that submission, and in my written settled reasons, I will explain why in a footnote. I do not have the benefit of a victim impact statement from R who is deceased. However, on the basis of Jay's account at trial, I am able to say that your offending must have had an immediate and significant impact on R. The defence submit that I should not speculate as to the long-lasting impact upon R. Whilst it is not possible for me to quantify the harm caused or articulate precisely how it impacted upon R in the long run, I have no doubt that it did in some way. I am mindful of the authorities which recognise that sexual activity with children is presumed to cause long-term and serious harm, both physical and psychological, to the child. I now turn to an assessment of the gravity of your offending. This first involves an assessment of the conduct itself. Your offending encompassed 2 distinct episodes over a month apart. In my view, the first episode in the pre-sacristy involved a brazen and forcible sexual attack upon the 2 victims. The acts were sexually graphic. Both victims were visibly and audibly distressed during this offending. The obvious distress and objections of your victims is relevant to my assessment of the impact of your offending on J and R. There is an added layer of degradation and humiliation that each of your victims must have felt in knowing that their abuse had been witnessed by the other. In relation to charge 1, this indecent act against R, in relation to charge 1, which is the indecent act against R, has, in my view, a nasty element to it. Holding him by the head whilst placing your penis in close proximity to his head. Whilst there was no sexual physical contact, the conduct here must have been particularly confronting and debasing. Judging by R's reaction, it clearly was so. Charge 2 on the indictment is a charge involving sexual penetration of J, and it is rightly characterised as an act of violence. Additional force was used by you to offend over and above the penetration, in that you grabbed hold of J's head and pushed your penis inside his mouth. You held his head down for a period. One of the indecent acts against J, being charge 3, involved direct physical contact with his genitals, which sets it apart from touching that occurs on the outside of clothing. I accept that the first episode involved opportunistic and spontaneous offending, rather than pre-planned or premeditated conduct. It is on that basis that you must be sentenced, and I take this into account. Had it been pre-planned or involved grooming, it would have been more serious. Turning now to the second episode of offending, while the indecent act in the second episode in the corridor was very brief and spontaneous and involved contact over clothes, it is, however, coloured by the fact that you had sexually assaulted J a month or so before. This squeezing of his genitals in the corridor cannot be viewed as an isolated lapse on your part. You had had ample time to reflect upon your previous abuse of J, yet despite this you still indecently acted against J, and did so with what I consider to be a degree of physical aggression and venom. It was by no means a minor indecent act. In supplementary submissions, your counsel submitted that the only inference that can be drawn from your offending in both episodes is that you were not, for whatever reason, acting rationally. It was submitted that the fact that you are an otherwise intelligent person who had never previously or subsequently offended just highlights that you must not have been in your right mind at the time of this offending. In particular, your counsel emphasises that no person thinking rationally would engage in the conduct of the first episode with the door of the pre-sacristy open and with people nearby, and where there were accessible private lockable rooms nearby. It was submitted that I should therefore proceed upon the basis that you effectively did not reflect in a reasoned way upon your offending. I reject this submission for a number of reasons. First, there is no medical or psychological evidence before me of any kind which supports any inference that your mental functioning was impaired or diminished in any way at the time of either episode. I note your counsel did not seek to engage the principles of mental impairment under the case of Verdens. Second, there is no evidence before me from any witness at the trial that you were other than a fully functioning, competent, lucid and intelligent man during the relevant period of time. To the contrary, there is evidence that on the day of the first episode you had successfully delivered Sunday Solemn Mass as Archbishop, this being a public role requiring discipline and focus. Third, in relation to the first episode, you offended over a period of minutes where there was ample opportunity for you to both reflect and to stop. On the evidence of Jay, you told the boys they were in trouble. Jay says that you all just froze. You then started moving underneath your robes. You then exposed your penis. There was thus time for reflection even at the beginning of this offending. What then occurred was sustained offending. Your sexual abuse involved multiple different activities and actions. You moved from one victim to the other. Your dialogue with the two victims during the first episode was both purposeful and responsive. You continued to offend with callous indifference to the victim's obvious distress and objections. At some point during the episode, you even told your victims to be quiet because they were crying. Fourth, what you did was so egregious that it is fanciful to suggest that you may not have fully appreciated this. Your graphic sexual misconduct was not of a kind where you may have misjudged its gravity. Fifth, The fact that you offended twice against Jay further undermines the explanation that your offending was but an irrational, unthinking moment of lunacy. As to what drove you to offend in such a risky and brazen manner, I infer that for whatever reason, you were in fact prepared to take on such risks. I conclude that your decision to offend was a reasoned, albeit perverted one, and I reach that conclusion to the criminal standard. To accept the argument of your counsel would mean that every offender who commits an offence which is brazen, out of character and spontaneous must be considered to have some form of mental impairment or some lapse in a capacity to reason or to think rationally. There is no basis in law or in principle for this proposition, and I reject it. Certainly you were confident your victims would not complain. I will return to this. In any event, I reject your counsel's submission that the only inference available is that you were not acting as a rational thinking person. If I am required to identify other explanations as to why you were prepared to take on the risk of somebody walking in on you into the priest's sacristy, then I do so. By the jury's verdict, this offending occurred, and no one walked into the priest's sacristy whilst you were offending. These are facts which I must act upon. You may at the time have been sufficiently confident that other church officials would not walk in during this period of time. You would have had some knowledge as to their activities and whereabouts at the time. Moments before you had walked from the cathedral into the priest's sacristy corridors, you would have had some opportunity to interact with others and observe their movements. Another possible reasonable explanation for your preparedness to take on the risk of somebody walking into the sacristy is that you may also have subjectively believed that had this occurred, you could control the situation. You may have thought you could control the situation by reason of your authority as Archbishop, whether or not that belief was well founded. Such a state of mind would have been extraordinarily arrogant, but the offending which the jury has found you have engaged in was, on any view, breathtakingly arrogant. These are all reasonable inferences available once it is assumed, as I must, that this offending actually occurred. I do not aggravate your sentence on the basis that you held any of these states of mind as to why you were prepared to take on the risks of somebody walking in. I simply highlight them as reasonable possibilities to further rebuff your counsel's submission that the only inference available is that you could not have been acting in a rational thinking way. I now turn to my assessment of the contextual circumstances and in particular to the issues of breach of trust and abuse of power. These are all relevant to my assessment of the gravity of your offending, including to your moral culpability. As Archbishop, it is true, as the defence submitted, that you did not have a direct, formal or standing role of supervision in relation to the victims, like that of a boarding master and boarder, regular teacher and pupil, or babysitter and child. Other adults were charged with directly supervising the choristers when they attended at St Patrick's Cathedral, most notably the choir marshal, who was a teacher. In my view, the concept of breach of trust in sentencing law cannot be confined to the narrow circumstances of formal supervision. Adults working at institutions no longer stand as mere strangers in relation to children who attend those institutions. This is because the institutional setting affords these adults with an opportunity to interact with children within that setting, an opportunity they would not have as a mere stranger. It is the opportunity of unsupervised interaction, implicitly granted by parents or guardians, which is the point of a child's vulnerability. The child no longer has the immediate protection of his or her parents or guardians. The power imbalance between adult and child is usually amplified within an institutional setting. Indeed, that disparity of power makes children vulnerable and may in fact deter them from bringing forward a complaint. The opportunity of interaction with children within an institutional setting must come with the responsibility not to act to the detriment of the child. If the opportunity to interact with the child within the institutional setting does not depend upon the adult being placed in an explicit or official supervisory role with respect to the child, then the relationship of trust surely cannot be conditioned upon this. No direct authority on point has been brought to my attention, but I think the position which I have stated above is supported by the general principles as to when the law recognises a relationship of trust within the sentencing context. And I should indicate that in my settled remarks all the footnotes will appear. It has been said by our Court of Appeal that, and I quote, "The exposure over recent years of the extent of the incidence of abuse of children in our community by persons entrusted with their care has created much distrust at all levels and threatened the very capacity of adults to interact in a normal, healthy fashion with them." The law needs to be clear and unequivocal here. The level of trust and the corresponding degree of any breach will often vary, but this should not distract from an acceptance of a fundamental relationship of trust between adults and children within institutional settings. Where the adult occupies a senior position within the institution, exercising power, authority and influence, any breach of this relationship of trust should be seen as grave. I consider this fundamental trust is an expectation which every parent is entitled to have when their child attends any institution, sporting, social, educational, cultural, religious or otherwise. This was as true at the time of your offending as it is today. In any event, Cardinal Pell, I find beyond reasonable doubt that on the specific facts of your case, there was a clear relationship of trust with the victims, and you breached that trust and abused your position to facilitate this offending. The following matters, when taken together, drive me to these conclusions. First, as Archbishop, you occupied the most senior leadership, official and religious position at St Patrick's Cathedral on the days in question. Second, there was a large body of evidence that the environment at St Patrick's Cathedral was hierarchical, structured and subject to strict discipline. Authority mattered within the cathedral and was very largely respected. You were a pillar of St Patrick's community by virtue of your role as Archbishop. Victim J gave evidence that the choir boys were expected to show reverence in your presence. The evidence shows that you were profoundly revered, Cardinal Pell, which imbued you with and legitimised your authority. As Archbishop, you did have a relationship of approval in relation to the choir boys. In part, the choir boys were performing to please you as Archbishop. There was evidence that you would from time to time visit the robing room to congratulate the boys on their singing. The choir boys were the least powerful and the most subordinate individuals at the cathedral. The victims themselves were 13 years of age. The power imbalance between the victims and all the senior church leaders or officials, yourself included, was stark. Third, the victims' presence and role within the choir at the cathedral were intimately connected to their schooling. They were required to attend choir as part of their scholarship conditions. Their role within the choir was effectively an extension of their schooling. You understood this link, as did every cathedral official. This educational connection and the school-like atmosphere with which the cathedral was imbued further reinforces in my mind the obvious relationship of trust which was cast upon you and other church officials in relation to the boys. Fourth, in both the first and second episodes, you came into contact with the victims because you were present at St Patrick's Cathedral performing official duties, as were the victims. The victims would have seen you presiding over or delivering Mass immediately prior to the offending. The victims themselves had just performed choir duties during these Masses. In both episodes, you were still officially dressed, as were the victims. According to the evidence, your role in Mass did not officially conclude until you had divested. In both episodes, the offending occurred in areas which were off limits to the public. In relation to the second episode, the offending actually occurred during the recession from the Mass. The full weight of your authority and position of power must have been very obvious to your victims and to you. Fifth, during the first episode, when you found the victims in the pre-sacristy, you said words to the effect that you're in a lot of trouble. Whilst being offended against, pleaded that you let them go. Your admonishment of the victims was an explicit expression of your authority over them. The victims were rebuked by you because they had breached a rule in their capacity as choir boys. The very pretext through which you committed this offending had to do with the strict discipline of the choir boys at the cathedral. Sixth, the brazenness of your conduct is indicative of your sense of authority and power in relation to the victims. In the case of the first episode, you did not seek to secure the door of the pre-sacristy before you commenced the offending. You offended against 2 victims despite the fact that the door was unlocked and despite the risk that either victim could have run from the room or later complained. I think you did give thought or reflection to this offending, and the only reasonable inference from the brazen circumstances of your offending is that you had a degree of confidence that the victims would not complain, either immediately or by running out at some later stage. The second episode was also redolent of your absolute dominance over Jay and control of the choir boys more generally. In my view, you did not say anything to your victims by way of threats to secure their silence because you've clearly felt that you did not need to. Seventh, while I consider that your offending was intimately connected with your duties and role as Archbishop and the victims' duties and roles as choir boys, on any view, you seized upon the opportunity presented to you to interact with the victims within the cathedral setting to abuse them. To conclude on this issue, the authority you carried within the cathedral setting in relation to the choir boys carried with it a significant responsibility of trust, not to do anything to the detriment of the boys. The argument of your counsel that this offending was committed by you, George Pell, the man, and not by you, George Pell, the Archbishop, must be roundly rejected. I do so without hesitation. Your obvious status as Archbishop cast a powerful shadow over this offending. Not only do I consider that you offended in breach of your relationship of trust and in abuse of your power and authority, I would characterise these breaches and abuses as grave. You were the Archbishop of St Patrick's Cathedral, no less, and you sexually abused 2 choir boys within that cathedral. This connection and the depth of the breaches and abuses is self-evident. I am conscious that the breaches of trust and abuse of power overlap here, and that one informs the other. Trust may be abused by the misuse of a position of authority. The conferral of authority and power can give rise to a relationship of trust. They interrelate in this way in your case. I am mindful that I must not punish you twice. Your counsel submitted that in assessing the gravity of your offending, I should take into account the absence of certain aggravating features, which are sometimes present in sexual offending against children. The additional presence of these factors, such as pre-planning, would have made your offending objectively more serious. Their absence is, nevertheless, not determinative of my assessment of the gravity of your offending, which I must carry out upon the basis of what you actually did. For example, despite there being no grooming, I have still found that you made a reasoned and deliberate decision to engage in this inexcusable conduct of the first episode. You had time to reflect on your behaviour as you offended, yet you failed to desist. To conclude on the question of gravity, the gravity of the offending cannot be assessed by reference to the particulars of the charged conduct alone. In my opinion, all of the offending, across both episodes, is made significantly more serious because of the surrounding or contextual circumstances, namely the breach of trust and abuse of power. This elevates the gravity of each of the offences. In my view, your conduct was permeated by staggering arrogance. I consider in particular that the sexual penetration offence is very clearly a serious example of that offence, and that the indecent acts encompassed by charges 1 and 3 are also serious examples of that offence. Viewed overall, I consider your moral culpability across both episodes to be high. I reject the submission of your counsel that the offending in the first episode, or the sexual penetration offence, was at or towards the lower end of the spectrum of seriousness. In my view, it does not even approach low-end offending. Moving on to some other matters. As I have already